Yes, Your Ladyship. Your Ladyship, the application is opposed by 2 affidavits sworn by myself and that one of the widow, one Margaret Munhaki Njoroge, both they're dated 7th of April, 2025.
They are sworn on the same day.
Yes, they were sworn yesterday. One sworn by myself, and the other one is sworn by the widow of Richard Otieno, deceased, who is the instructing client in this matter, both dated 7th of April 2025.
They are dated
7th of April 2025. Yes, I believe they are in the court's record. Yes, they were filed yesterday.
Yes.
And Your Honor,
Let us know
yes,
how much time they are taking.
Your Honor, 5 minutes. Yes. Your Ladyship, I believe I'll be opposing this application by the defense counsels on the following grounds and reasons.
Are they there?
Yes, Your Honor, they in my replying affidavit.
Right.
Yes, on my replying affidavit in its entirety. But, Your Honor, an advocate has a right to act for any client, and the client has a right to appoint an advocate that he or she desires. Actually, it's a constitutional right.
He has a right to act for any.
Client, any client, and any client has a right to appoint an advocate he or she desires to represent him or her in any matter. And therefore, Your Ladyship, I submit that it is a constitutional right to be represented, the client should be represented by a counsel of their choice. And Your Honor, the instant orders that are sought by the defense counsel in the application is to have me barred from appearing for the family in the murder trial. And Your Honor, appearing for the family in the murder trial, I believe Your Ladyship, this infringes the right of representation. The counsels for the defense have submitted to this court that there might be conflict of interest. And Your Ladyship, I believe it is true the right of representation may be limited in certain circumstances, and where possibly that I, as an advocate, being called as a witness to present a case or a conflict of interest for that matter. And Your Honor, there is no indication before this court that I'm likely to be called as a witness in this murder trial. Neither have I recorded a statement with the police
That you are able
to be called as a witness in this trial. Neither have I recorded any witness statement with the police, nor the prosecution nor the prosecution have given any indication they intend to summon me in this particular trial. Your Ladyship, the applicants herein.
You have not been submitted? Sorry? Okay. There is no evidence, you have not recorded statement?
Yes, with
The
the
police.
nor any indication that they intend to summon me during the trial.
So there is no indication that you are likely to be called as a witness?
Yes, in this murder trial. That the applicants, my Ladyship, who are seeking to have me disqualified from watching brief for the family in this matter, must of necessity provide a proper basis to the court to enable make a determination. And Your Ladyship, in response to me having meeting the second accused person and having lengthy talks regarding the matter, and even agreeing to represent him in this court, Your Ladyship, is false. No evidence has been tabled nor exhibited before this honorable court.
The allegations of meeting
The second accused person and having a lengthy talk regarding this matter, the instant matter, the second accused person, and having a lengthy talk regarding the instant matter, and even agreeing to represent him in court. Your Honor, my Ladyship, is false, since no evidence has been exhibited before this honorable court. And also, Your Ladyship, I submit that the argument that there is a client-advocate relationship the argument that there is a client-advocate relationship between myself and the accused person is a misplaced argument, Your Ladyship, in that, for instance, no demonstration that I was paid
relationship with the woman.
advocate-client relationship, the second accused person, is a misplaced argument. For instance, no demonstration that I was paid legal fees to retain my services. And neither did I draw any documents on behalf of the second accused person. Any documents that was drawn under my name. Equally, Your Honor, my Ladyship, there is no evidence that I called the police officers to have the accused persons arrested by the DCI. Simply because it's the duty to arrest any person, the police officers. That duty is for the police officers and not myself as an advocate. Equally,
I think, okay, I'm not interrupting, but the issue that came up is not that you were arrested, but that you told
yes,
the police to arrest and hand it over the accused persons to the police. Is that what is, that is the issue?
That's
It's not that you are arrested.
Yes, Your Ladyship, and I believe that is, I want to tell this court that that is false, because never have I met the accused persons there before until I came to this court.
So you had met them before you appeared in court?
Yes,
With the minutes?
and I believe. And I believe that no evidences to that has been tabled before these courts. I was just 1 minute, Your Lordship, to conclude. Actually, all the other allegations, Your Honor, cannot be substantiated before this court. And I believe, Your Honor, some of them, for instance, I feel they are personal. If you read paragraph 19 of the applicant's affidavit, 19. If you read from paragraph 14,
So you refer the court do not, is not speaking, and it is reminder. The most you can do is direct her to where? Not substantiated.
yes, that is from
Then you're
paragraph.
saying, you're asking me to get there by your particularly paragraph.
That is paragraph 14 to paragraph 19 of the applicant's
Paragraph
19,
is that 14 or 19?
19,
Paragraph 19.
14 to 19.
I asked you.
Yes,
Well,
Your
which
Lordship.
one is which one?
14 to 19.
Yes, paragraph 14 to 19.
Yes, actually, they are unsubstantiated allegations because, my Lordship, the issue of payment of 100,000, if that was done, why did the accused report to the relevant authorities? That is the ESCC. We have the police and so on, because it shows that the advocate wanted to bribe them. Further, I want to read paragraph 19 verbatim to this court.
Paragraph 19.
Yes, of the applicants.
My lady avoided that because of the directions you give that we don't
Yes.
become personal. But if she wants, if she opens up that,
Okay. I'll look at it. You are saying
Paragraph 19.
14 to 19.
Yes, my
You want to put emphasis on paragraph
19.
19. That will survive. But you also, you had mentioned the habit.
that one it's okay.
That one is
But
okay.
paragraph 19,
You see now, I don't have the application here, access. But you remember what I said about?
Yes, my Lordship.
Maintaining the decorum
Very well.
etiquette.
Yes.
Yes. To this noble profession.
True.
Yes. So that if you retain, I'll surely look at it. Yeah?
Yes, because
Because you say it, okay. You say, why did they call me? You see,
to record that I was about to bribe them with 100,000 or any other relevant authority for that matter, because corruption in Kenya is a crime.
okay.
Your Lordship,
We have said that you emphasize paragraph
19. Yes, Your Lordship, because I feel it's personal. And as a female advocate, I feel aggrieved.
Says paragraph 14, paragraph 19. The piece of the affidavit.
That is on the applicants,
On the application, on the affidavit.
the application. Your Honor, in summing up, I wish to submit that a client has a right to be represented by the advocate of his or her own choice. Your Honor, I have a track record that will be captured in the sworn affidavits of Margaret Mihaki, who is the wife of the deceased, that I used to represent the deceased.
So you paragraph or the whole of
Yes, the whole affidavit. Even when, yes, the deceased, even when he was alive. And for the information of these points, here, I'm doing the work, I'm doing the representation pro bono because the family cannot be able to hire a lawyer. It's very important for the court to know that.
Yeah, hearing
Pro bono.
for the family
Pro bono, because they cannot be able to hire a lawyer because of their financial constraints in the economy. So, Your Honor, the application is made in bad faith. Full of malafidus and has not met the threshold.
It is in bad faith then?
Malafidus and has not met the thresholds for the orders sought, that the orders to be sought to be granted. And it should be dismissed with costs to the applicant. Let me check that is. Thank you.
Should be dismissed with
Costs
costs to the applicant.
to the respondents. That's all, Your Lordship, and thank you.
So, we want to have some order whose application it is,
Yes, I want to support Ms. Wamaiva.
or you support.
Yes. In that application has been made to have a request from the
This is
matter.
Mr. Kuto.
Yes, this is Mr.
That's
Kuto.
what you support.
Yes.
That's what the others did.
And I only want to make, just want to take 1 minute. Your Honor, Mr. Mangeri's application is live on the testimonies or affidavits from the accused persons in this matter. And that is the reason why the court should warn itself whether that particular...
You have already received statements.
Yes, I'm saying,
Have you already received statements?
Yeah. yes, I have looked at the,
Let me get it.
I'm looking at the application that is before you
Yes,
and the supporting affidavit.
yes.
And I'm saying those supporting affidavits have been made by the accused persons in this matter.
I think that was a warning line. And my colleague cannot comment on this. It can only say he supports, and that's the end of the story. Yes.
They are made by accused persons.
Yes, so the court should warn itself, even when it is entertaining those affidavits. Because what is before this court?
And the affidavits were found, I don't have that application. The affidavits are sworn by,
Yes, the
are
accused.
sworn by accused persons.
Yes, it is there. It is there with David.
And further, Your Honor,
Wait a minute. You ask this court to do that.
so that goes to the property value.
You ask this court to do that.
That goes to warn itself. I want the court to warn itself. Even when it is considering those affidavits, it should warn itself because they have got an interest in this matter. And we don't even know the reason why
Why considering the application?
Yes, the reason why.
Done.
Secondly, Your Lordship, what is before this court is a murder trial of the state against 5 accused persons, and not Mrs. Omaida. Mrs. Omaida is not under trial in this court. And even some of the reasons, Your Honor, you look at paragraph 14.
We cannot comment on those paragraphs. I will object.
I'm not deliberating, but I'm making
Yes.
my objective.
So, Your Honor, I support our application on those grounds.
I give directions.
Yes,
You just say I support. You have to say it. Okay, I allow you to make that comment for everybody else to make that comment. That the statements are recorded by the accused persons. Simply
The affidavits.
The affidavits.
Yes, as one by
Just
the.
one myself.
Yes.
Just that. But in the fathers have gone. Next. Who else?
Yes, your next. Your next.
Yes.
I'm not going. We are playing together with Mr. Michael.
You support her?
Yes, but I want to give some addition.
Additional on what? Additional on what when there is no affidavit? You had my directions. Did you hear my directions?
I have your directions.
You cannot really put a point of law, any issue to do with law, nothing else.
Yes, and that's exactly what I want to do.
Let's hear.
On behalf of the public, we are stating that under the Victim Protection Act, Section 9.
On the Director of Public Prosecution. The role of an advocate watching brief for the complainant is limited. And I place my reliance on Section 9, Clause 2, Section 9 of the Victims Protection Act. Yes, yes.
So you support?
That is all, my lady.